And this is 24 DCCR 1151. Mr. Bruno was previously in court, entered a plea of guilty to evading arrest or detention with a motor vehicle. I have received that pre-sentence report. Has everyone had an opportunity to review the report?
I have none.
Are there any additions or corrections?
Negative.
Mr. Bruno, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, the case will actually be dismissed at the end. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty, so you would become a convicted felon, and you could be sent to prison for anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. See, Jose Contreras, Mr. Parker, it's also sentencing. Good morning, you're Jose Contreras.
Yes,
And Mr. Contreras, in cause number 25 DCCR 0006, was previously in court, entered a plea of guilty to the state jail felony offense of failure to comply with sex offender registration requirements. And I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Have your honor.
State does.
Any additions or corrections?
Nothing more, Judge.
Open state.
All right, Mr. Contreras, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, obviously this is a great opportunity because you don't have this conviction on your record. And if you successfully complete the probation, the case will be dismissed and you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and sent to the state jail prison for up to 2 years. Do you understand? Obviously, you understand now the importance. If you move, I know things get, it looks like you were in the middle of some things. You cannot miss this reporting. Your reporting period is not that long. You've only got a couple more years, I think, on it. So make sure you do it properly between now and then. You shouldn't have any issues. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to go over your paperwork when she's ready, okay? All right, good luck to you, sir. Diamond Ollie. Give me this. Y'all are gonna have to give me a second because I just did something. I'm not quite sure. What'd you say? Oh, it's got, something's happening. Morning.
Morning, Judge.
Sorry.
This technology sure is good.
Isn't it great? Go paperless, they say. It'll be so much more efficient.
As a solo, I find this true. I can't imagine how that it would go well.
Let's try this again. All right, you're Diamond Ollie. And Will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Ali, in cause number 25, DCCR 0532, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual, and that's from February 1st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Speak up, please.
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Is there no fine?
No fine.
And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Ali is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report done. It'll just give me more information about you and your case, and then we'll go forward with sentencing at a later date. You need to stop and talk to probation on your way out of the courtroom today to start that process, and she's sitting at that desk right over there.
Your Honor, this is her lawyer for the CPS case, and I've talked to the caseworker, and the caseworker has informed me that she has been working the program. She's done everything she's supposed to have done. There's only
Right.
a couple things. It's her husband, who she's was recently married to, who's completing some of his classes. And she has other kids that she's seeing all the time, and she has this child she hasn't seen. And it upsets that kid when he sees the other kids leave. And we're wanting to see what we can do about reunification. That's the goal, what the court's position is on that, and she may be able to speak more to that than I
That's why
can.
I came judges to be a friend of the court, and I have emails from the caseworker too, just
And if you, just for the record, if you'll state your
My
name.
name is Courtney Wheeler. I'm the attorney appointed to Ms. Ali in her CPS case.
So what is the status with CPS with regard to contact between the child of the victim in this case?
The only reason that she's not getting contact with the child victim of this case is because it's part of her bond conditions that she can't. So it seems like both courts are at a bit of a stalemate, which is why I offered to come today. She has worked all of her services. She's completed everything except for the ones that are ongoing, like counseling, which she's participating in. Even though she doesn't get to see that particular child, when she buys stuff, supplies, food, snacks, toys for the two she gets to see, she includes him on that, so the gifts are sent home to
How
him.
old is this child?
He's 5.
5. So here's what I will do. Mr. Hoffpower, do you have any issue if I make it just between now and sentencing at least supervised? And then once we get to sentencing, I can get more confirmation through the pre-sentence report of the status of everything?
Just for the court's information, the state's been included on all emails between CPS and Parker, so I know
Okay.
all what's going on. I'm okay with whatever the court decides.
So what I'll do at this point is modify the bond conditions, Ms. Ali, to allow you to have contact with, is it Casey? Okay, and so, but it's going to be supervised only, and at least until we come back for sentencing, and then I'll decide at that point if it's still supervised for some amount of time or not, depending on all that information that I get. So for now, supervised with just as some competent adult. I'm sure you can talk to your attorney about what that means, and then we'll see where we get when we come back for sentencing, okay? Thank you for coming. And Ms. Ali, make sure you stop and talk to probation on your way out, okay? We'll see y'all back at sentencing. And Mr. Parker, you've got Stephen Wilburn, that's also a sentencing.
You don't have to do that for me, George.
All right, sir, you're Stephen Wilburn?
Yes, ma'am.
This is cause number 24, DCCR 2346. Mr. Wilburn was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
Any more, Judge?
Judge, although safety was not part of the original plea, obviously, of course, it's up to the court's discretion, and based on Mr. Riley being so thorough in his PSI, I would stand with his recommendation.
Your Honor,
Seeing as how he put it out in bold, et cetera, that safety or some other form of residential treatment proposed.
Your Honor, I just went to the court, his last offense was 24 years ago, and he's got a full-time job. He worked for Performance.
Yes.
I think he's a welder,
Yes.
and we would ask that he not be sent to safety, and be monitored some other way as far as his alcohol consumption. Obviously, he understands that he can't drink. He and I've talked about that.
Or possibly hold that in abeyance, Judge, if you're considering, so that, I mean, my concern is over the holiday period, if we're not here, it could be brought to the probation department's attention and in the courts, even if we're not talking.
All right, makes sense. So here's what I'm going to do, Mr. Wilburn. Obviously, you've had a very long-standing issue with, it appears to me, with alcoholism, and I understand that you're Mr. Parker's position. Your last DWI was a very long time ago, but your history prior to that was not good, and I don't want you to go down that same path, obviously. So what I'm going to do is I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, follow the agreement, and find you guilty of driving while intoxicated, third or more. Sentence you to a term of 10 years in prison, but probate that for 6 years. You will be ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That means some of those rules and conditions are the standard rules, but in addition, I am going to order that you enter and successfully complete the safety program, but I'm going to hold that in abeyance. What that means is that it's already ordered. If there's any hiccup at all, two things could happen. One, they could just send me over a piece of paper, it gets signed, you go to safety, period. I've already ordered it. Two, I don't have to do that. You could be revoked. So it's very important that you follow all of the rules. I am going to order that you enter and successfully complete the JCDI program. That is an outpatient, intensive outpatient treatment program. So you will be ordered to successfully complete that. You will get started on that. Your officer will let you know how to do that. I am also going to order, at least for some time, that you wear a scram device. That's a device that will detect alcohol in your system. If there is any alcohol in your system, obviously you're either in safety or you're in prison, one or the other, immediately. And so you need to get that scram device within 48 hours of today. They'll also let you know how to get that taken care of. And you're also ordered as a condition of your probation to serve 10 days in jail. That's required. And so what are your hours of work?
Right now, we're on 7/10s until after Christmas, but we are having 3 days off for Thanksgiving. I can start it then 3 days. I'm sure we'll have a few days off for Christmas.
Well, it's difficult to just say, okay, you're going to do 3 here and 7 in a month or two. I mean, obviously, I don't want you to lose your job, but we've got to get the 10 days done. So what I will do, I mean, you have some time off on vacation, things like that, that you can take. I don't mind doing a longer period of time over the Thanksgiving break, and then I mean, do y'all want to look at a calendar and come up with 10 days, Mr. Parker?
Is it 10 days consecutive?
It does not have to be. No, you can do weekends, and I don't mind spreading it out a little bit, but I need specific dates. 10 specific dates between, I mean, we're already in November now and the end of the year. I wouldn't mind working a little bit around that, but I need the exact dates. So why don't y'all talk real quick about those dates, and then I'll recall the case and I'll put those on so we have those for the order. Mr. Rojas, you have Krisha Bennett, or Krishara, I'm sorry. Good morning. Good morning, ma'am. You're Krishara Bennett. And will your client waive the formal reading of the indictment?
She will, Your Honor. We'll be emailing you.
Okay, thanks. Ms. Bennett, in cause number 25, DCCR 0062, you're charged with a third-degree felony offense of credit or debit card abuse against an elderly individual from November 14th of 2024. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would not be a fine. You would be ordered to pay restitution in the amount of $2,256.92 and also to forfeit your home health aid license. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Bennett is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to the probation department on your way out of the courtroom today, and she's sitting at that desk right there.
Judge, may I just clarify for the record, whether she has a license or not? I know it reads that way, that she is not allowed at all
Absolutely.
based on the nature of the offense and stealing from her.
Yes, so you are not, as a condition of your bond right now, I'm going to make a condition of your bond that you are not allowed to provide any type of home health service, whether it's licensed or not. And then a condition of your probation will be the same. Obviously, that you forfeit your license, but that you cannot go do this type of job even without a license. Do you understand? All right, stop and talk to probation on your way out of the courtroom, and then we'll see you at sentencing.
We've got the dates, Judge, when you're ready.
Okay, y'all can come back up on Stephen Wilburn. All right, this is back on the record, and what are the dates?
He wants to start November 26th at 6 p.m. And then he'll do 26 through 28. And then he'll do every weekend after that, reporting it Friday at 6 p.m.
So that every weekend then would start on the 5th of December. I mean, because the 28th is a Friday, so you don't want to go ahead and go through that weekend?
You're going to do to get out Sunday, correct?
Yes.
So it would be the 26th through the 30th then?
So is the 30th a Sunday?
Mhm.
Yeah, you get out Sunday, yes.
Okay, so the 26th through the 30th, so we've got 26. That's 4 days. And then we need every weekend, starting December 5th, until it's satisfied. So you will report then on Wednesday, November 26th at 6 p.m. You'll serve 4 days to be released on Sunday the 30th. Then you will report back that next weekend, Friday at 5 o'clock. They'll let you out on Sunday, and that will be until you complete the remainder of those 6 days. It's important that you are on time not late, that you show up every Friday. It's a condition of your probation. So if you don't show up or you're late, then you're in violation of your probation. It's also very important that you don't show up intoxicated. Some people think it's a great idea to show up drunk. They're going to sleep it off while they're there. That's a violation, so don't do that as well, okay? All right, have a seat here in the courtroom. Probation will call you up. Actually, hold on, I didn't finish this. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
All right, the court is calling 2025 CR 002103, State versus Jeffrey Patrick Smith. Can I have parties announced?
Tilden Schaefer for Mr. Smith, Your Honor.
Kurt Grancy, co-counsel with Tilden Schaefer.
All right, counsel, have you received all discovery and did you review it with your client?
We have and we did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smith, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it? It happens. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You're not.
Any objections?
No, Your Honor.
Did you review the court admonishments with your attorneys? Did you understand it and sign it in all the appropriate places? Did you understand in count one, you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. Range of punishment. Just 1 second. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no, ma'am.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine. State is proceeding on count one only. There's an affirmative finding of deadly weapon. There's no application for community supervision. You don't qualify for community supervision legally. There is an application for deferred adjudication, and the state is recommending deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
None ruled on, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with the complainant, MRT, anger management, driver safety and gun safety courses, forfeit the weapon, and understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, first, why should I follow this plea bargain agreement? Okay, anything from Vince?
Judge, I think this is a situation where my client greatly regrets what he did. It's a situation that got out of control. And I think based on his background and age, it's one of those, we should have made much wiser decisions. He doesn't have a violent background. And I do know, and I think the court can tell from how he's answering questions, there's quite a bit of regret in this entire affair, Your Honor.
All right, so why did it come to this?
Your Honor, it was just a messed up situation that night. I wish I could have made a different decision. You know, my son was in the car with me. I was worried about his safety 100%. And I'm a minute that hasn't gone by since this has happened that I wish I could have made a better decision that night.
Okay, I understand what you're saying, but I still don't understand how an argument on the road comes to a pulling of a weapon. I just don't understand that. And they're asking for a driver safety course. They're asking for a gun safety course. They're asking that you forfeit your Horseshoe Bay badge credentials. And they're saying that you flashed a badge and that you were no longer employed with them. So I'm just trying to figure out what conditions would be appropriate for you. This is why I asked these questions, because
I only
there's a lot listed.
used the old time to diffuse the situation. I thought it would help. That was it. There was no other reason behind it.
Why did you still have the badge?
It was given to me by my chief of police at the time as a memento, because that was my first job there before I went to Border Patrol.
So where do you work now?
I've left I left Border Patrol in 2016. I went back to construction. I'm a home inspector for new homes. Till this happened, I was planning on going back to actually apply for ICE. That's null and void.
I mean, but here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
No, so Judge, he has a suppressor, and so his parents live near Kerrville.
Okay.
That's what the mother and father, they had gone out to her birthday celebration that night. He was going home with his son. And they have it's in a rural area, so they actually have kind of a setup where they do target practice. The suppressor has more to do with not making loud bangs. That's why he had, and it's legally owned. He's got the stamp for it. I have it in my file back, trial file. It's not illegally possessed. Otherwise, I guess the feds would be involved in this case, Your Honor. That's why I had the silencer. I can tell you that there was a perception on my client's part that the kid was tailgating. Then there was a brake check, which you can see from the statement and the police reports. And then the kid comes around really close, rolls down his window, honks at him, yells, starts cussing, and it kind of goes from there. It goes kind of south. I think I think my client thought he could handle the situation. He thought he would diffuse it with the badge. That didn't work. And then at the moment when this all happened, apparently the young man had a phone in his hand. This was at night, and he made a gesture kind of with his hand to the side, which at that moment in time, my client, who was already kind of freaked out, thought it was a gun. And this was an apparent danger case, Your Honor. Police didn't find a gun in the kid's car, but that's what we saw. We actually, in the subpoenas, dug up extraneous acts where a kid had got in trouble at school for posting shots on social media with him with guns. And he's holding it the same way he was holding the phone. When he's talking to the police officers, he's holding it, he's pointing like this. So that's the gesture my client saw in that moment. He made a mistake. We've spent a lot of time on this. The state has spent a lot of time. They showed us a new witness who was the girlfriend of the young man in the car at the time that nobody had ever found. We'd always wondered, why weren't they looking for the girlfriend? We couldn't find her. We didn't know her name. Ms. Alban did a great job preparing for trial. And that's kind of why we're here today, Judge. I think both sides have kind of met in the middle. Again, my client doesn't have a violent background. It's just thank God that he didn't hit the kid. So that's why we're here.
Oh, is there something else?
Well, I mean, I'm not sure it's clear. The gun was in the car because of going out target practicing, but he had gone and met his family for dinner, and he was going home, and they were in the back seat of the car, in a bag. You know, it wasn't as if he routinely carries a gun.
He had been target practicing at his parents' house prior to dinner. He actually had a concealed carry permit, which he's since had to relinquish. The state revoked because of this.
Is there anything else?
No, Your Honor.
Anything else from the state?
Is happy with this resolution. I would, the court would like to hear now, I do have a restitution amount, but on the judgment. Would like.
Yes.
It's $2,463.82.
I'm sorry,
Okay.
just 1 second. If you could repeat that.
$2,463.82.
So is there any disagreement on that restitution amount?
No, I think that was part of the discovery. And we actually had the receipt from the repair shop, Your Honor.
And where will you have that restitution amount?
Judge, I think it's going to take a couple of months if the court would entertain that. He started this job about June, maybe, and so there's been some lag time. And I mean, he is the independent contractor, so lag time in taking the jobs and getting paid.
All right, just 1 second. Excuse me. Everybody on this side, y'all need to move because probation can't see and they can't hear what's going on. All right, so when do you think it will be? Oh, and state your excuse. When do you think he will have that?
If I had, I would say a minimum 2 months.
Yeah, 60 days.
All right. And that's 60 days from today? All right, this is what the court is going to do. The court, and I'm going to tell you, I was considering sending you to jail as a condition. But the state is saying that the complainant is in agreement to this being your sentence. So you can thank the complainant for that. Because sometimes I feel as though people need to have a chance to be alone in their thoughts at the jail to consider everything that is what they've done. And it appears that you've taken that into consideration. And it appears that on this night, everything that could go wrong did go wrong. But don't brake check people. People don't like to be brake checked. That's just my experience from driving. All right, 5 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, And I'm sorry, what do? You said you're in construction?
Yes, ma'am. New home inspections.
All right. He can do regular random UAs, or either you can do the patch. The patch costs more, but with the patch, it gives you more freedom because probation will put it on and probation will take it off. Patch costs more though. So you can either do regular random UAs or the patch. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 120 hours of community service restitution. I'm going to require parenting classes. Once you complete that, the community service hours will be deemed satisfied. MRT, the anger management course. You're to forfeit the weapon, and you're to forfeit your horseshoe bay badge credentials. There's to be no firearm possession. There's to be restitution in the amount of $2,463.82 to Joseph Pettis, and that's to be paid in full within 60 days. There's to be no contact with Joseph Pettis. There's to be no employment with law enforcement or any type of security. There's to be field visits one time per month for 6 months. Are you here in Bear County?
Yes,
All right. Probation, is there anything else? All right, and I'm sorry, there's a $1,500 fine that will be probated. Is there anything else that you need from the court?
Yeah, Judge, in regard to employment, if some of the jobs are out of county, I know some are in contiguous counties, but if they're further, can he get permission to do that if he shows probation where he's going?
Yes.
Okay.
Probation, he's allowed to work throughout Bear County and other counties, but you'll need to provide notification to probation that you're going to be working out of county. Working in county, that's fine. But if you're going out of county, you need to let them know. All right, is there anything else?
And I just, actually part of the plea bargain was actually to not only just waive, but to actually dismiss the set count two. I don't know if that was clear. You did do it, you waived it, but that is part of the inducement for the plea is that, and it was to be.
Oh, I've already said that it's been waived. It's on the record.
No, I understand that, but I'm just being hyper-technical.
No. I understand what you're saying, but I put on the record that
Yes.
it was waived and you all had no objections to it being waived.
Correct,
So
correct.
it will not come back.
Okay.
It's not allowed to come back.
There you go.
'Cause-
That's what I
All
want.
right,
All right,
thank you.
Sorry.
No problem.
All
Did you, and I'm sorry, there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, communication with probation is key. If there's an issue, you need to let them know about it. If you feel they're not addressing it, you can always come back and address it to court. But whatever you do not disappear on probation. That's not a good look. You understand? All right, good luck to you. Thank you.
Thank you, Your Honor.
You're welcome.
Let's go to Louisiana. Let's make that happen. There's somebody, looks like a witness is going to appear from a car, so that, for some reason, always tends to get interesting.
Parole panel. And on the panel this morning, my colleagues here in Baton Rouge is Ms. Carolyn Stapleton. Joining us remotely by Zoom is Mrs. Jerry Ledoux. We are at DOC headquarters in Baton Rouge, so I'd like to ask the staff here to please introduce yourself for the record.
Carla Williams.
Francis Abbott.
And our first remote location this morning is at Claiborne Detention Center. And I believe we have Mr. Como before us.
Yes, ma'am.
Mr. Como, would you introduce yourself? Tell us your name and DOC number.
My name is Merlin James Como. My DOC number is 441810.
All right, Mr. Como. Let me acknowledge the guests that we have here who are here in support. And their sisters, 3 sisters, Contessa Como, Andrea Como, and Katrina Como. And so we'll ask for their comments shortly. First, I'm going to read some identifiers into the record, and then I'll ask you if that information is true and correct. And then I'm going to turn it over to Mrs. Ledoux because your case has been assigned to her this morning. You ready?
Yes, ma'am.
So, Mr. Como, you're classified as a second felony offender. You're currently serving an 18-year sentence. You were sentenced in Acadia Parish in January of 2011 for one count of indecent behavior with a juvenile, and your parole eligibility date was November 30th of 2018. You don't earn good time, so your full-term release date is November 29 of 2027. Is that information correct?
Yes, ma'am.
All right, Mrs. Ledoux?
Yes, good morning. Mr. Como, have you served 15 of your 18-year sentence?
Yes, ma'am. I'm coming up on 16 years.
Coming up on 16. And I was a little confused reading your report regarding the classes you've taken. I saw where you had started phase 1 and 2 of the sex offender treatment, but were you removed for disciplinary reasons? And have you ever completed that course?
I was removed because where I was taking the class at, a table had got destroyed, and my name, I was written up for it, but they couldn't provide footage proving that I did that, so they just kicked me out the classroom and never reinstated me. You know, and those write-ups were dismissed.
And so have you requested to be
Yes, ma'am, I
after
have
this
requested. Yes, ma'am, I have requested right after I was kicked out of the class. You know, I asked to be reinstated, and they had transferred me over here.
And they don't offer that at the facility that you're in, correct?
No, ma'am.
Okay. So you have one count in this particular case. Was this an isolated incident, or because I have the record, just to be honest, was this an isolated incident?
Yes, ma'am.
Okay. I don't see in your file any transition plan to return to society. So what were your thoughts about that? Because I know you have to have an approved residence plan for the particular crime that you're on. So what are your thoughts on that?
Well, my family, my 3 sisters that support me, you know, they have housing that they have did research on that I will be able to go to. Plus, prior to my incarceration, you know, I was in the transportation industry, and you know, I would like to go back to that, but you know, I understand I might have to start at the bottom, you know, and work my way back up, you know. So, but for the most part, you know, I've learned a lot on this during my incarceration. You know, what it is to be resilient, what it is to have discipline and be patient, no matter what trials and tribulations I may face and go through. It's not what I go through; it's about how I respond to it.
So I didn't delve real deeply into your disciplinary conduct because you have been write-up free for the last 3 years. But how many DBs do you have in your jacket?
I don't have none that I'm aware of because I've been over here at this facility for going on 5 years in January, and I haven't received a write-up.
Okay. Okay. Are there any members of the staff there who could speak about, so what is your job? What is your job currently?
I don't have a job at this facility, and you know, it's just
They don't have anything for y'all to do. It's just doing time.
Yeah, it's just doing time. I mean, they do have trustees in positions and stuff like that, but you know, I mean, I
Can
don't,
you have,
I guess I don't, you know, I'm not with the politics, you know, it's political.
okay. So you never took pre-release or substance abuse?
No, ma'am, when I was in Allen Parish Correctional Center, I was taking NA and AA and stuff
Uh-huh.
like that, but that was in like 2015 and 16, but I got transferred from there.
Okay. Okay. I'd like to hear from your sisters at this time. Um, who wants to go first? Which one? Yeah. Okay.
I can go first. I'm sorry, I had some issues unmuting my phone. Good morning. My name is Tessa. I'm Merlin's younger sister. And actually, I have actually been doing research. I spoke with a couple of people. There's two homes in where we live. There's one in Lafayette called Sober Living. There's also another one in New Iberia that houses strictly sex offenders. I've been in contact, very close contact with both of them. They're both waiting for me to respond after this hearing. We have a bed already ready. I've looked into the programs. I've also spoke with Miss Ethel, who has an outreach program here in Lafayette that I'm sure you guys are familiar with. The homes that I've spoken with, they are fully vetted with the Louisiana Board of Pardon and Parole. So they both said that he would qualify. They were looking into some more information. Miss Ethel Thibodeau with Beacon Connections, it's a community outreach. She's prepared to help with sex offender fees, housing. We have a lot of resources. My other sister who's actually on the phone, she works for a similar program, a day program, and she also has a lot of resources. So we've gotten information on just like curfew, the programs, different things that's offered in these homes, different type of support groups. There's also one in Lafayette called Sober Living where they have to go to church and they have to receive therapy so many times a week. They have to find a job. So I have a lot of information that I can send over to you guys if you would like. But we've definitely been looking into things and just trying to help him to transition back into society because I know it's going to be a challenge being that he's been in there for a while. But we're willing to help however we can.
Okay, great. Thank you very much.
Yes, ma'am.
And the next person, which other sister wants to speak
I'll
now?
go. I'm Chandrea Como, ma'am. How you doing?
Good.
Well, I'm his younger sister, and I have a CDL license. My brother also, he held a CDL license before he went in, and we looked into the process of getting his fee. A lot of fees have been waived because he's incarcerated. So I think now his balance to get his license back is like $800. They just waiting for him to get back to go to the DMV to get on a payment plan. And I have jobs, like I have a lot of connections with jobs to get him back rolling. You know, I know he can't go like far out. He got to stay like in the city or whatever, but I have a lot of connections with jobs. They just need him to get out to fill the application out. We have a lot of connections. People are willing to help him.
Okay, great. And the last sister. Sorry, I don't have a name in front of me.
Hi, good morning. My name is Quatrina Como, and I thank you for allowing the opportunity to speak on behalf of my brother Merlin. I just want to say that my brother has been incarcerated for years, and during that time, he has reflected deeply on the choices that led him there. Through these years, I've seen a real change in him, not just his words, but in his attitude and the way he carries himself. He's grown in faith, humility, and gratitude, and he truly understands the seriousness of his past and has taken full responsibility for his actions. The man he is today, not the same man who entered the system all those years ago. My brother often speaks about wanting a second chance, not only to rebuild his life, but to also be a positive influence on others. He hopes to use his story and his experiences to teach other young men who may be heading down the wrong path and to help them understand that every decision matters and that redemption is always possible through accountability and change. He is committed to becoming a productive member of society, to work, to give back, to live a life of integrity. And all he is asking for is the opportunity to show that the lessons he's learned were not in vain, and that no matter what mistakes a person has made, it's never too late to change. As his family, we will continue to support and encourage him as he takes the next steps in his journey. I know he can't change the past, but I also know that he's truly remorseful and he's ready to move forward in a positive and a meaningful way. I thank you for your time and for considering his request for parole.
Thank you. Well, I would say, Mr. Como, that you are extremely blessed to have the sisters you have. And they have spoken very positively about you, but I want to hear from you. What have you learned during this time about your behavior that sent you to prison? And I mean, we've read all the details. So you tell me, what have you learned?
I have learned that, what it is to, live a life on life's terms. Prior to my incarceration, I was abusing, cocaine, and I was making choices, that led me here, and I understand that, and as I got older, I got wiser, and rehabilitation, a lot of these places, they don't offer it, but it really starts within. You have to take accountability and responsibility for your actions, and nobody's perfect. We all have our flaws, but I understand what it is to be a man. I understand what it is to go through things and how to respond to it, and I really have learned my lesson and things like that. I'm not a violent individual, I'm not a career criminal or anything. And, I'm willing to do whatever it takes, to reintegrate back into society and to be that member, to take care of my family and my loved ones that has been there for me for all these years.
Yeah, well, talk to me about about the impact on your victim. I mean, that's one thing I haven't heard any of your sisters talk about, or you. I want to know what you've come to understand about the victim impact.
What I come to understand is that the victim, has suffered, mental anguish. And since then, the victim, we have, put our differences aside and, forgiveness, I was forgiven and things of that nature. And, I'm really, remorseful and sorry for my actions, my crime and everything, and I understand that, what I did, was not right,
How not right? How not right?
It wasn't right by the laws of the land,
It's not right morally either.
Morally,
it's not right
yes, ma'am.
as a father. It's not
Yes,
right.
ma'am.
Okay. I'm going to allow my colleagues to ask some questions. I want to reserve to be able to come back. But if my colleagues would like to ask some questions.
Yeah, I mean, I follow along the same path as Miss Ledoux. When she asked you the questions about what do you think about your victim, you talked only about yourself and that you're forgiven and all of this kind of stuff. But I don't think you have a clue what that must have done to that child at all. So even all these years later, I don't think you've reflected on how bad what you did was. So I just, that's all I have to say about it. I don't see any changes there.
I'm sorry, ma'am. Is it okay for me?
No, ma'am. No, ma'am. I'm sorry. Mr. Como, you've been before the parole board twice. You were denied both times in 2018, 2021, and the reason stated each of those times was the need for sex offender treatment, because at that time you hadn't had it. So you've had phase 1 and 2, right?
I took phase 1, 2, and 3, and I went to came up for parole in 2023, and they said I had victim opposition, which was untrue.
Right, I did see there's no victim opposition today, but your record that I have only shows phase 1 and 2.
No, ma'am, I took phase 1, 2, and 3, and I was testing out. I was at the end, and I
You
got
must not
transferred.
have got credit for 3 if that's when all that stuff with the table happened. Maybe they didn't give you credit for 3. Do you have contact with your daughter or her mother?
Yes, ma'am. My daughter, she wrote me a letter, and she told me, she needed me, to be in her life. Yes, I am in contact with her.
And do you, well, that's all I have for now. Ms. Ledoux, you want to follow up?
Obviously, Mr. Como, you have to have pre-release prior to release. That is just one of the requirements that the state has put into place. And that has not, do they have pre-release where you are?
No, ma'am.
Okay. And there's some things that are missing in the puzzle piece. I think that with the completion of your sex offender treatment and your pre-release, then that gives me the confidence knowing that that's been completed. And the support that you have from your family, obviously they've worked very hard to come up with that. Let me tell you one of the things that, the way I think about this is that you're going to be off paper in 2027. And if you are released in 2026, you will have time on supervision that the Department of Correction will be able to supervise you and know how you're reintegrating. Does that make sense?
Yes, ma'am.
Have you been on supervision before?
I was on probation. This was way back in like 2000, 2000 to 2001.
Yeah. But you have to understand this is going to be a very intense supervision. Okay. With no option if you ever got out before your full-term date. I'm prepared to vote. I'm going to vote to grant your parole conditioned upon completion of the sex offender treatment and pre-release with approved plans and with increased substance abuse testing and a curfew. I want to have this period of supervision so that, because you have no victim opposition, there's no opposition to your release. You obviously have support. Your evidence-based evaluations are good. So I think that this period of supervision with some additional would be helpful for my mind. So that's my vote today.
All right, thank you. Mrs. Stapleton?
Well, I agree with everything Ms. Ledoux said. I mean, she's put on some very good conditions, and that would be necessary because you are fixing to get out. It's not a long time. So that would ensure that you would continue your treatment plan. And so I concur with Ms. Ledoux.
All right, Mr. Como, I do agree. We need, documentation that you complete the sex offender treatment. We'll send you back probably to buy you door cheats so you can finish that program. Do you understand the other conditions that Ms. Ledoux laid out?
Yes, ma'am. It's just the pre-release. Will I have to take that over there too, or I'll be transferred somewhere else?
They have it. I think they have it there.
Okay, so y'all gonna make sure that I get transferred to these facilities because it's nothing that I can do on my own.
I know, but we can get that done.
Oh, I would like to add that I think you only should have supervised contact with the victim while you're on paper. I think that needs to be a supervised contact so that we understand and you understand that that's a you're not to be alone with the victim until you're off paper.
Yes, ma'am.
All right, so, well, you got a little bit of work to do, Mr. Como. But you've been great. Go, let's
Do you understand how, do you know, like how long would it take, like for me to be transferred over there?
Well, we're just gonna make the request to DOC and we don't have any particular sense of how long it'll take, but usually they do it as quickly as a bed is available. So good luck to you. That concludes our business there at Claimer.
Let's check in on Judge Glazer. Let's see what's going on there. See how it's going this morning for her.
Judge. Sir, stay away from the Whole Foods store at 2910 Biscayne Boulevard in Miami, Florida. You're not allowed to go to that location. You must stay away from there, sir. He's 71. Well, that's what his page is. What do you want your bond at?
So it's not food, it's alcohol, right? 10 bottles of champagne, $1,500.
I'll set your bonds at $1,500. Have a nice day. Stay away from Whole Foods. I give you a little break in the bonds. Mr. Alexander, if you have a case, you look on the calendar, tell them what page it's on, and that you can pull it out of turn, okay? Will you come and take it out? Tell the clerk to take it out. Harold Ortiz, we got to tell corrections. Mr. Ortiz. Good morning, sir. English okay or Spanish?
English is fine.
English. Sir, good morning. You were arrested for driving with a suspended license, third or subsequent conviction. I will appoint the public defender's office for you.
Your Honor, find PC for a permanent revocation. If Your Honor looks at the defendant's priors, I see.
There's probable cause for driving with a license permanently revoked. Would you consider pretrial services for Mr. Ortiz, Judge? I don't think so. He almost ran down some pedestrians.
Right, he's got multiple felony convictions for driving without a license.
I had signed up.
On $2,500. Good day, sir. No driving unless you have a valid license. Robert Jackson, page 10. Good morning, sir. You were arrested for possession of cocaine. I will appoint the public defender's office for you. You had 20. Was it intent to sell 22 baggies with cocaine? State?
Yeah. It looks like intent.
There's probable cause for possession with intent to sell cocaine. Your bond is $7,500. Next, Marlon Murphy, page 11. Good morning, sir. You were arrested for possession of cocaine. I will appoint the public defender's office for you. There's probable cause. Is he eligible for any TAP maybe or a program? Do you have a place to stay, sir?
I would have you find no probable cause. They're just saying that they find a loose piece of crack cocaine in the same area.
I'm giving him a program. There's probable cause. We went TAP or pretrial.
Not eligible for pretrial. He's getting TAP alternate bond, $1,000. He has a, they always said he's not eligible for pretrial. I'm giving him TAP. Does he have an address?
Yes.
And then you can get out of jail for free with TAP, sir. Have a nice day. Next, we have on page 11, Roy Barnhill. This is the slowest calendar today. I feel like I've been here forever.
It's only 11 though. We're not doing so bad.
Jeez. Good morning, Mr. Barnhill. You were arrested for petty theft, 2 or more convictions. I will appoint the public defender's office for you. So it's alleged he's stealing, what else? Walt power tools. That's what everybody takes from Home Depot. He has a conviction for petty theft from July, 28 days. Sir, you are ordered to stay away from the Home Depot store at 19400 Southwest 106th Avenue in Miami, Florida. You are not allowed to go to that location. You must stay away from there, sir. I'm setting a bond. I'll set it at $1,500 because you got recent convictions. There's one from July, one from May. Maybe I shouldn't lower it. Sade, are you okay if I lower the bond to $1,500?
Judge, would you consider a program for Mr. Barnhill? He just got a really good job.
1,500 is okay.
To lose it?
For 4 months.
It's 2 recent convictions plus last year, $1,500. I lowered
That if he loses his job, then he also might lose his place when he's finally getting.
Well, he may be facing prison sentence. I don't know, but he's presumed not guilty, but there's probable cause. He has a conviction from July and one from May, both for petty thefts. Stay out of the Home Depot. Alex Argueta. Page 11. Good morning, Mr. Argueta. You were arrested for child neglect and burglary with an assault or battery with prejudice. This is a case from November 6th. I will appoint the public defender's office for you. Please give me a moment to review the arrest affidavit for probable cause.
Judge Glazer putting a lot of thought into this one. Well, that's good. That's what they're supposed to do. Happy Friday, everybody. Welcome again to the Courtroom Files Live. It's good to have you all here. I put this in the chat, but just so everybody's aware, game night will remain on hiatus at least for a couple more weeks, so we will not have that this Saturday, even though I'm back, because something has to give in my schedule at the moment, so that's going to give for a couple weeks. All right, looks like she's figured stuff out. Let's go back to Judge.
Gone since the date on the arrest form. He's already been into the court system to go through legal proceedings in the family court regarding the child custody matter.
Okay.
Judge, I would ask Your Honor would consider a bond for him.
I don't know if it's child abuse or child neglect. Yeah, she's charged properly with child neglect, pardon me. I'm giving him a bond. It's going to be no bond. I'm granting the state's motion for pretrial detention pending final hearing. Your order to stay away from Haiti Bustamante, the alleged victim, that's the mother of the child. No contact. She should have been ordered to stay away from her father because he punched him when he's in the car. He punched him and gave him a bump on his head. State, where's my other non-domestic stay away order?
There's only one victim on the back of the A form.
No contact with Haiti Bustamante, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court. Do you understand the stay away order, sir?
Yes, ma'am.
So I think it's really good that you went over to family court and filed a petition to determine paternity. So just so you know, we're all human. Everybody makes mistakes, okay? And you made a big mistake by what's alleged here, but I'm required by law to hold you with no bond.
Judge, you do have the discretion to
This is one where I am.
set a bond, Judge.
I'm not so
bad. It just happens in a car.
It happened in a car and it was very violent and it's pulling a child through a car. I'm not trying to take the child from the mother and hitting the mother and the father. I'm not giving him, I'm holding him with no bond and granting the state's motion. The judge on Monday revisit it. There's going to be a hearing Monday and that judge can give him house arrest or set a final hearing.
Judge, he has no criminal history, Judge. I would ask Your Honor if you would set a bond or even an ankle monitor so you know he's apart from her.
I can't do that. I'm sorry. I recognize he's young. He made a mistake, but I can't have to hold him no bond unless the state's going to agree, and I doubt they will because she never agrees when she files a motion.
No. Unless I hear from the victim, no.
The victim's not here to give her input either, so I'll set it Monday and hopefully maybe the state will have a chance to reach out to the victim. It's no count one, the child neglect. I'll set it at $1,000. Count two, the burglary and assault or battery. There's no prejudice. It's no bond. Good luck to you, sir.
Judge, with regard to the stay away order, since they're going to be in family court proceedings, which have already been filed, I would ask at least
You can attend all. I'm
during
not sure.
time, Judge.
Let me just see.
It's
Those are usually done on Zoom. I'll put attendance at a family
No,
court
I think-
hearing regarding custody will not be a violation of the court's order.
Judge, I just get confused by these cases because there's other cases that come before this court every day where there's allegations of more severe violence levels than a punch, and they get a bond all the time or bond.
Everything's different, and I look at case by case, and I don't.
Somebody without a record, Judge,
Miss Corey,
not a stranger. I'm just asking for a bond.
I understand. I don't
So he
feel comfortable doing that, not based on what I read here. It was really violent. They're yanking a child through a window, hitting the mother and hitting her father who's driving. It's very violent. I think it should be held with no bond.
There's just other cases that have higher levels of violence and they're getting bonds here.
I don't know. I look at each case by case, and the division judge.
We just had an attempted murder here a few days ago, Judge. He got a bond plus house arrest.
Which one is that?
That was Mr. Brown.
Who's Mr. Brown?
The football player. That was here.
There was probable cause for an aggravated assault with a deadly weapon. That's not an.
That was a firearm, Judge, which is a lot more dangerous than a fight, Judge, with unknown.
That's a third degree felony. This is a first degree life felony. It's a different charge. I have to, when you enter a vehicle, which is not yours and you don't have permission and you commit a crime therein, that is a first degree felony, burglary with assault or battery. And he batters the people inside.
The court would find probable cause for burglary, assault, and battery, but essentially the violence level is a punch.
The victim had a bump on his head and he's yanking a child. So I don't know the laws. I'm not always happy with the way the law is written. I just try and follow it. There's probable cause for first degree felony. It needs to go before the division judge on Monday. That judge will set a final hearing on the state's motion. For pretrial detention, that judge can also decide on Monday to give him a bond, but I'm not doing that. If you're not happy with the court's ruling, please file an appeal. Maybe they'll change the law, but I can't. That's not my job to change the law.
So I gotta say, personally, I'm in support of what the defense attorney was saying right there. I'm also in support of what the judge said and the fact that she can't change the law. But we did see that. I mean, we opened up the other day with the Antonio Brown case right in this court where he ran to Dubai to avoid charges of attempted murder. Comes back because he's extradited into New York and then extradited into Florida, and he gets a $25,000 bond and house arrest, where this guy is going to get no bond. Now, I'm not saying he should have a bond. He should probably sit based on the facts as we heard them. But again, how is it that a guy who is accused of attempted murder and runs halfway across the globe to avoid it get a bond? Well, this person does not. So yeah, there is an imbalance there, and I would tend to agree with the defense attorney in this case. I also get what the judge is saying, but it's messed up, it's broken, and at some point somebody's got to fix it. Yeah, Mr. Brown was Antonio Brown. We covered that the other day. You might have missed that show, Lindsay, but we cold opened right into that case where he was in front of Judge Glazer for his bond. He had already pleaded guilty the prior day pleaded not guilty, rather, the prior day to this charge, and then he appeared in front of her for the bond hearing. So, yeah. I don't know. Doesn't make sense to me, but, maybe it's just me. Again, but I'm not saying this guy should get out. I don't think either one of them should. I mean, why does the guy who runs halfway across the globe get a bond? Because he's famous? Why does that happen? It doesn't make sense. Let's go to Louisiana. Let's make that happen.
2025, time is 9:02 a.m. My name is Cheryl Renassa, serving as chair today. I'd like to ask for a roll call, please.
Ms. Renata?
Here.
Ms. Stapleton?
Here.
Mr. Prater?
Here.
Mr. Tibbetts?
Here.
Mr. Freed?
Yeah.
Madam Chair, we have a call.
Thank you. We are at DOC headquarters in Baton Rouge. I'd like to get the staff here at headquarters. Please introduce yourself for the record.
Bill Cavalier.
Jacqueline Falcon? She is reporter. Parole.
Francis Abbott.
All right. Our first item on this morning's agenda is review and approval of the minutes from Thursday, October 30th, 2025. Those are included in your packets. Are there any corrections? All right, I'll entertain a motion to approve the minutes.
I'll make that motion.
Second.
We have a motion by Mr. Prater, second by Mr. Freeman to approve the minutes from Thursday, October 30th, 2025, as presented. Is there any objection? Hearing none, those minutes are approved. And so we're ready to start our regular business. The next item is consideration of application for clemency or pardon, and we will allow public comment on requests before any action item. So our first remote location this morning is at Catahoula Correctional Center. Mr. Augustine, good morning.
Good morning, Mel.
Are you, is there an officer in the room with you?
Yes, ma'am.
Hi, I'm Tanya Stevenson, the transition specialist.
All right, thank you, Ms. Stevenson, for accommodating us this morning. So, Mr. Augustine, would you introduce yourself, tell us your name and DOC number?
I'm Anthony Tyrone Augustine, DOC number 430160.
All right, Mr. Augustine, I'm just going to read some identifying information into the record. I'll ask you to verify if it's correct, and then I'm going to turn it over to Mr. Prater, seated to my immediate right. Your case has been assigned to him, so he'll take it from there. You ready?
Yes, ma'am.
All right, Mr. Augustine, you're here this morning seeking a commutation of your sentence. You were sentenced in the 12th Judicial District of Boyles Parish in August of 2000 for a manslaughter conviction. You received a 40-year sentence. You do have a good time date, which is December 23rd, 2033. Is that information correct, sir?
Yes, ma'am.
All right, Mr. Prater.
Okay, Mr. Augustine, how are you today?
I'm okay, sir. How about yourself?
Okay, I'm doing good. I'm doing good. Thank you for asking. Okay, we've got a number of people here that are in opposition, and we'll get to those in just a minute. But what we like to do as a board, we like to find out a little bit about you and a little bit about your history since being incarcerated, how you've done, and what you think about the crime. And then we want to hear from somebody from Catahoula there, if there's anybody there that would be willing and knowledgeable to speak about your behavior at the institution. So to begin with, Mr. Augustine, would you tell us what got you put in jail and what you think about the crime and what you've been doing since then?
Well, February 2021, I committed a horrible crime that, I wish I could take back, but I took the life of a mother, a daughter, a sister, a friend, and I hold myself accountable for the actions that I have done. But since my incarceration, I have taken numerous classes, such as substance abuse, anger management, cage and rage, thinking for a change. I have several Bible courses at colleges that I've completed and graduated from, GED. But like I said, I'm holding myself accountable for what I have done, and I have worked hard constantly and still working daily to become a better person, a better man, a better brother, a better father, a better friend,
Okay. All right. Well, that pretty well wraps up your statement. You've covered all the high points of what I wanted to hear. Let's hear somebody from Catahoula. Who's in the room there with you? I'm sorry, I missed the name.
Tanya Stevenson, the DOC transition specialist.
Yes, ma'am. Do you know this fellow very well and how he's behaved since he's been there, and how long has he been there?
I'm not sure how long he's been here, but he has no behavior problems. He was a trustee here at the main facility, but he's at the parish jail where he is a trustee there.
Okay. All right. Well, thank you. I appreciate that information.
You're welcome.
Okay, well, let's move on now to those folks. We don't have anybody speaking on your behalf that have signed up to speak, but we have a number of people to speak against this request for a commutation of your sentence. And so we'll begin. We have three people that will be speaking. We have Kia Greenhouse Allen, we have Cheryl Lewis, and we have Casey Greenhouse. They will be speaking. Now, there's a number of people that are here in attendance, and I don't know if you can see them or not, but it's J-Nex Greenhouse Jr., LaShawn Dixon, J-Nex Greenhouse Sr., Marie Jacobs, Chiquita Greenhouse, and Kim Greenhouse are also here, but they will not be speaking. They're just here for support and or support of each other, I would say in opposition of your request. So between Kia, Shara, and Casey, I will let y'all decide who will be first. When you speak, would you go to the podium? Please speak up so we can hear you good here at the board and on the microphone, and tell us what you have to say as far as your opposition. So whoever would like to go first, please introduce yourself.
Hi, I'm Sheree Lewis.
Okay, and let me apologize. I'm sorry, you were on Zoom and I was introducing the folks that were here also. Yes, ma'am, you're on Zoom and introduce yourself again.
My name is Sheree Lewis,
Okay,
and I'm Sabitra's best friend.
okay. And tell us why you're in opposition for this.
Basically, because and I hear when he says that yes, he want to change, that he change and becoming a better person, but on the other end of it, he gets a second chance. Like he gets a second chance at life or whatever. My friend don't get a second chance, and he was selfish. I mean, he took a selfish move. You took her because of being selfish, and you left her child there with her, and yet you think you deserve another chance, which no, I'm not God and I'm not doubting that, but I'm just totally not for it. No.
Okay. All right, Miss Lewis, we appreciate you taking time to give us your thoughts on this. Miss Allen or Miss Greenhouse, who would like to go next?
I'll go next. Hello, my
Okay.
name is Kia Greenhouse Allen. I am the cousin of Sabitra Allen. I wrote a statement. I would like to express my strong opposition to the potential parole of Anthony Augustine for the murder of Sabitra Greenhouse. His actions not only resulted in the tragic loss of an innocent life, but they also left a lasting void in the lives of her daughter, Casey, and our family. Sabitra was murdered in her parents' home, a place that should have been a sanctuary. With this brutal act, Anthony robbed his child of her mother, leaving her to grow without the love and guidance that every child deserves from their parents. This senseless act of violence not only affected the victim, but has had a profound and painful impact on our entire family. Anthony does not deserve a second chance in society. His crime was not just a moment of anger. It was a calculated decision that shattered so many lives. I can never forget the words of the priest at her funeral. He stated that these were not the actions of a man, but that of a beast. The consequences of his actions are lifelong and cannot be undone. I urge you to deny his request for parole, as releasing him would bring injustice not only to the memory of Sabitra, but also to our family and the community that continues to suffer from this loss. Thank you.
Okay, thank you, ma'am, for taking time to be on Zoom with us, and we'll continue on then with the opposition. Now, Miss Casey Greenhouse, who is here at headquarters. Miss Casey, would you go up, Miss Greenhouse, would you go to the podium? There you go. Introduce yourself and tell us what's on your mind.
My name is Casey Greenhouse. To the honorable members of the Louisiana Clemency Board, my name is Casey Greenhouse, and I stand before you as the daughter of Sabitra Greenhouse, who on a crime was committed against on February 21st, 2000, at the age of 18, by my biological father, Anthony Augustine. I am here today because my father murdered my mother. I was only 6 months old. The story I have of that horrific day is that my mother was sitting in the same room with me, working on her schoolwork so she could graduate high school and create a better future for the both of us. I was told she was young, hopeful, and determined. She was doing everything right, working hard for her life and for mine. But all of that was taken from her when he I was left in the room beside her lifeless body. I was found only because my aunt unexpectedly became ill at school and had to return. I cannot imagine how long I would have remained in that house, alone with her if my aunt had fallen ill that day. That is how my life began, not with safety, not with love, but with violence, trauma, and a state of experience. My 6-month-old life began with the loss of both my parents because of his choices. I grew up without a mother and without the father who should have protected me. I spent my childhood wondering what my mother's voice sounded like, what her laugh sounded like, whether my style looked like hers, whether my shoe came from her, there was, and but I would never know because she was silent before I ever had the chance to remember her. My mother never had the chance to record videos, take pictures, or leave behind the way people do today. One of the most painful of many things I grew up with was the longing to hear my mother's voice. I would wonder what she sounded like, and then it would hit me. At least he still has a voice to this day. Yet my mother remains silent and forever will remain silent. No videos, no saved messages, nothing. I grew up watching other children make Mother's Day cards, but I had no mother to give one to. I watched other girls have their hair brushed by their mothers, get help picking out dresses, get cheered for school sports graduations. I never had any of that because I was robbed from my mother. She wasn't there for any first days of school, my birthday, my heartbreaks, my first job, my college applications, my adult decisions, any milestones that should have been shaped by my mother's love. She should have been here. She should have been there for my wedding one day. She should have been there to help me prepare for motherhood when the time comes. She should have had a chance to be a grandma, but she won't, because that was taken from her. Every single holiday, celebration, and ordinary day has been marked by her absence. I grew up emotional anxiety, sadness, and a deep abuse that words can barely describe. My entire identity was shaped by a crime I did not choose, a loss I could not stop, in a moment I was too young to remember, but will spend the rest of my life healing from. Ag did not just take my mother's life, it destroyed two families. My grandparents, aunts, and uncles raised me too. They're only three walking on eggshells, so they didn't speak out of anger about my father. For 26 years, emotions, trauma, and unspoken pain were bottled up so that they would not hurt me further. They had to comfort a crying baby one morning, their murdered daughter and niece. No family should ever endure that. His family suffered because of his choices. They lost him as well. This was not just a crime against one person, it was a wound that spread across generations. In 2020, I received a letter, and in that letter, there was no apology from my father, no explanation, no accountability. Nothing that acknowledged the lifelong pain caused by your choices. Wrote that you love me, but I must ask, how could you love me, left me alone in a home with my mother's lifeless body? Why was the mercy in that letter for me? For your actions? There was not a sense of remorse to that day that could be sensed at any point in that letter. How could you claim you love me while abandoning me in the darkness? Most terrifying moment a child could ever experience. Growing up when I struggled with depression, while wondering why not me instead of her? And even worse, I feared that when you got out, you might come back and finish what you started. That fear existed and continues to exist because of what you did. How can I form a bond with someone who never cared about me from the beginning? How can I trust you? How can I open my life to someone who hurt my husband in front of me and abandoned me immediately after? You love me so much, why did you just walk away from the relationship? I think you choose freedom and raise me like a father should. Instead, you chose violence. You chose this. You chose to destroy our family and the future I should have had. And now we're here. For your child, your daughter, forced to stand before a clemency board, begging, pleading, fighting for her mother because of the actions of her own father. I'm pleased to agree or at least or to do any kind of mine with someone who never cared about me from the beginning. Someone who robbed everything that mattered the most in life. That is not love. Today, the man who caused all of this pain is asking for clemency, asking for mercy, but I ask this board, why was the mercy for my mother? Why was the mercy for me? The 6-month-old baby left crying beside her body. Why was the mercy for either of our families who have carried this trauma for decades? Mercy was never granted to us, to her. Why should it be granted now? Where was the clemency when she was carried by 6 while you were still breathing and had opportunity to be judged? Clemency cannot bring my mother back. It cannot restore the life she was building. It cannot give me the childhood I lost. I never heard, or the memories I never got to make. Instead, her choices destroyed our created generational trauma and forced lifetime and I answer questions. For 6 years, I've lived an emotional roller coaster, begging, pleading, and fighting for justice for my mother, because the person who should have protected us chose not to. This has shaped our life, and today I speak it to honor what we lived through and ask for justice that reflects that reality. Great, not be justice. It'll be different to the lifelong consequences of his choices. Let me see if I can do what was done. It cannot bring my mother back. It cannot give me the chance to hear her voice, to hug her, to know her love. Great clemency in this case would not be just. It would erase accountability for a choice that was both selfish and irreversible. I have lived every single walking day with the weight of this tragedy. For all these reasons, I stand before you, requesting you to honor my mother's life, honor her dreams, honor the silence she left behind, the silence created by violence, not choice. Let justice remain firm because of her still influence. I respect from the earth's support to deny clemency that is still mercy remains. Let justice remain firm because mercy was already stolen from us the day she was murdered. I would like to thank you all for this opportunity to stand before you and have with my mother.
Good job.
Thank you very much for the reading that to us. And we also have been supplied that letter and read it. And I honestly had to take a break from studying my cases after I read that letter because that was tough. Well worded and good letter. So thank you. And while I'm talking to you, I'd like to give a special applaud or whatever to your grandparents, the ones that raised you, stepped up for you. You had wonderful sports. Okay, back to you now, Mr. Augustine. I guess you heard what your biological daughter had to say. And before we get into this part, which is the question and answer session from the board, but I'll leave that off and then we'll see if they have any questions. Also, I want you to understand, we have read your file, so there's a lot of things that didn't come out in our interview. The fact that you are a first offender, I want to acknowledge that. This was your first felony arrest, that you did get your GED. You said that in your opening statement, but I saw that and I was particularly impressed by that one of your supervisors there in the work release, I believe it was, but the security supervisor there did write a good letter since they've known you, which is the time you've been incarcerated, that you've been a model prisoner. And I know that, and I can look at your face and I can tell that you are remorseful in all of your statements. But also you need to know that the DA, the sheriff, and the sentencing judge were all opposed, and all of the victim family was opposed also. So anyway, I don't really have a lot of questions to ask you. You got a 40-year sentence on a plea bargain, correct?
Yes, sir.
Okay, and you served how many of those 40 years?
25 years and 9 months.
Okay, and you'll be getting out, a good time date is in 2033, regardless of our decision today, correct?
Yes, sir.
Okay, I don't have any other questions.
Let's go, one question. I saw you lost 45 days of good time, but I didn't see no DV reports. What you lost that for?
Well, I got transferred to Winsboro, Franklin Parish, in a 6-man cell, and they came down a shakedown because they got a tip that a guy had a phone. So when they found the phone in the cell, that nobody owned up to the charge, but everybody got charged
In the cell.
But I got it restored, and when I went to court, I beat the charge, got dismissed, and I got the 45 days restored.
So it wasn't drugs, it was a cell phone.
Yes, sir. But on my route sheet, I have it. It showed that it was restored because it was.
Yeah, I see that.
Yes, sir.
Okay. All right. Is that all you got, sir?
That's it.
Anybody else got any questions?
I got one thing that I noticed on your commutation application, which goes back to, I didn't hear you say you took any crime victims, awareness classes when you were talking. I might have missed it or something. Did you get anything that said crime victim awareness?
No, ma'am, the facilities that I was at, they didn't have that program, that class.
Okay, well, I did notice that after all these years, when you put in for your commutation, it asked what was the reason, in your own words, for the offense. And one of the things that you say is because I just couldn't bear having my only child taken away from me for no reason besides her daughter's mother being spiteful. So, I don't know.
I don't remember, I don't recall that right there.
You don't recall that? Well, that was part of your statement, so maybe you want to kind of rethink that. That was something that stood out to me. Okay, thank you very much.
Well,
All right, I don't see any other questions, Mr. Augustine, so I think we are prepared to vote. Mr. Prater voted first.
Okay, because of the victim opposition, which was very touching because of the other law enforcement opposition, because of the fact you took a plea bargain and because of the fact that you gonna get out earlier than expected anyway, and you took a plea bargain 40 years and you took someone's life, I don't think you've served sufficient time, although I wanna tell you, I'm impressed with your behavior and the efforts that you've made there, so I don't wanna leave you without hope or anything, but I do honestly feel like that you need to go ahead and serve some more time.
Mr. Freeman,
I concur with Mr. Prater.
Mr. Tillings,
I agree with Mr. Prater.
Mrs. Stapleton.
I concur, Mr. Prater.
All right, Mr. Augustine, received 4 votes to deny your application today. So today your application for commutation's been denied, sir. Good luck to you.
Well,
In the meantime, we're on the record in the matter of the City of Wyandotte versus Terry Hernandez, 25608.
Good morning, Your Honor. Arthur Brand, P11126, appearing on behalf of the defendant who's seated to my left.
Okay, and Ms. Hernandez, your name for the record, please.
Terry Ann Hernandez.
Okay, today's the date scheduled for sentencing on your client's plea to an amended charge of disorderly conduct. The original charge of possession of controlled substance was dismissed by way of resolution between counsel. And there's also a bond violation hearing because it shows that your client missed drug testing on October 15th, 28th, and November 3rd, and tested positive on October 16th for cocaine.
I'm aware of that, Judge. Yeah. What do you want me to address first, the sentencing or
the bond violation? The bond violation, counsel.
Well, regarding the first violation, my client called me on the telephone and said she didn't have the money.
Counsel, is your client pleading guilty or not guilty to the bond violations?
Pleading guilty.
Okay, Ms. Hernandez, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, I do.
And you just speak up, ma'am, because you're very muffled.
Yes, I do.
Okay, thank you. And ma'am, you heard the allegations regarding the bond violation, correct?
Yes, I did.
And you, as to those allegations, how do you plead?
I plead guilty.
You understand your rights as it relates to bond violation, correct?
Yes.
And you understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea.
I do, Your Honor.
And knowing all that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, if you can please voir dire your client.
I didn't hear what you said, Judge.
Please voir dire your client.
Okay.
For the factual basis.
On the 2 dates in question where it is alleged that you failed to appear for urine testing? Did those dates occur?
Yes,
And on the date in question, when it's alleged that you failed a drug test, did that
Yes.
happen?
yes, it
And what
did.
what drug was involved?
Cocaine.
And is it a fact that on that date you violated the order of the court by using cocaine?
Yes.
Thank you.
Counsel, there were 3 dates that your client failed to appear for drug testing, not just 2.
Oh, I'm sorry. 3 dates. Is that correct?
Correct.
All right. Thank you.
All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violations. And counsel, what do you want the court to know regarding those bond violations?
Well, I have no excuse for what happened. I mean, you made it clear to my client, and she understands that she had to take those urine tests. I will tell the court that she had called me, I think it was before her first, I can't be sure of what date, before the first time that she failed to appear. She indicated to me that she didn't have the money, and I told her that I would loan her the money, I would give her the money. And so I'm surprised that there were other violations, to be honest with you. I know that my client is trying. Obviously, she's not trying as hard maybe as she should be trying. I would tell the court my client is in therapy at the guidance center at the present time. I'll tell the court that she has her only source of income is Social Security disability, for which she receives about $1,400 a month. I wanted to address what I thought was a very fair recommendation by the probation department.
Well, counsel, I'm sorry. Let's just hold off on that for just one moment.
Sure.
Is your client potentially interested in treatment court?
I do attend NA, Your Honor.
No, that's not what the judge is talking about. Are you interested in treatment court, which would be a program where you would be in a very intensive program to try to get you away from these problems that you obviously have with drugs? Are you willing to go into a very intensive program, is what the court is asking, where you would be monitored on a regular basis, and the court, not only you would be taking urine testing and other testing on a regular basis, but you would also be monitored by the court?
That's fine. I can stay at my home and take care of my dog.
What's she saying?
They're not asking me to stay somewhere, right?
I'm asking you, are you interested in going into such a program?
I'm
Just a plain old yes or no would be helpful.
yes.
Okay.
Okay. So then let's do this. We're not going to hold the sentencing today. I'm going to indicate that your client is interested in treatment court. It may be best for the drug court that's there in Lincoln Park. That may be the best fit for your client, but I'm not sure. In the meantime, so ma'am, you'll get information from probation as to contacting the 25th District Court, Sobriety Court. In the meantime, the court's going to order 10 days jail on your bond violations. You are to report tonight. So you're going to have to contact probation as well to get that information about reporting.
Understood, Judge.
Could I speak?
My client
What do
wanted.
you want the court to know, ma'am?
Your Honor, I have a home and a dog. I understand I made a mistake.
You made four mistakes, ma'am. You
I-
didn't go to testing 3 times, and then you used cocaine.
Your Honor,
That's in addition to the reason why you're here in the first place, but go ahead.
I have a dog at home. I have a responsibility of a home on my own. If there's any way that you could give me something other than jail, I have been doing community service at Trinity Church. I have been going to church on a regular basis. I realize I have a problem. I want to help myself. I'm not ignoring it, Your Honor. The times I didn't go, it's because I just didn't have the money. It's a hard life out there when you're a single person trying to live on $1,400 a month.
Ma'am, did you notify into probation? Did you email probation? Anybody?
I don't do email. I tried to call. You can't get through. on
And
site.
that's why we tell people to email, because we have a lot more people calling than we do have staff members.
I don't do email. I don't even have a
In fact,
computer.
your attorney even offered to loan you the money. So, ma'am, you have until 6 o'clock tonight to report. You have somebody that, you can find somebody to take care of your dog
That's fine.
and lock your house up while you're in custody.
That's fine.
Don't say anything else.
Have a good day.
You too.
All right, let's go off the record for a moment here. Okay, Mr. Stemke, we have Ally in here now. Mr. Spellman. Attorney, is that Spellman, Mike Spellman for Discover Bank? I need you to unmute, I think. Okay.
Yes, thank you, Judge. Yes, Judge, Mike Spolman, P41216. And Judge, I'm of counsel for Buckles and Buckles today on the Discover Bank versus Timothy Rice matter.
Okay, all right. I'm just looking to see if Mr. Rice is present. I don't see that he is right now. So I have the in custodies I have to handle, and then I will proceed with some of the other matters that we have. Ms. Penzelis, I have not forgotten about you. I just have a couple other matters that I've had to.
Mr. Rice is in the lobby.
Oh, okay. Mr. Rice in the lobby, Mr. Spellman. So we're gonna he's gotta go in the breakout room. So we can, and that's him in the defense counsel one.
Okay.
Okay, Mr. Ewing?
Good morning. Yes, I am present. Sean
Good
Ewing on
morning.
behalf of
Why are you on Zoom? Mr. George is here in person. Did we indicate this is done on Zoom today or no?
My notice to appear dated September 29th states we are directed to appear at Zoom, and it has the court's Zoom information.
Okay. All right, so I'm gonna move, the person that's in the MIDC in the office, can you please unmute and turn on your camera? And Mr. Harkness, I understand that the defendants have not shown up on yours, so that will be pretty quick, but I have to do the in custody first.
No worries, Your Honor. I'm working on other stuff.
Okay. So, Mr. Spellman, I'm going to put you into breakout room 1, and as soon as Mr. Rice is logged in, I'll put him in there too.
Thank you, Judge. Then we'll report back shortly to the court.
All right, thank you. Is somebody out there helping Mr. Rice? You just let me know when you're ready, girls.
Yeah.
Oh, there he is. Okay. Do you have Mr. Rice in there, Mark?
Can you hear me now, Your Honor?
Yes. Do you have Mr. Rice in there?
Yep. I'm gonna put him on with his name right now.
Okay, very good. Thank you.
Okay, give me a second. I'll rename him.
I got it. Okay. So that's going to be breakout room 1.
Okay, Your Honor.
Yeah. She's good. I don't know where that. I don't know where that is. Oh. Huh.
Did 3 get closed out from earlier?
Well, I don't know where it's at that I put up. I just renamed. Yeah. Wait, I named him just as Rice.
Yes, I did.
Yeah. Oh, you did? Okay.
It's Timothy.
It's not showing up to where to join the, oh, hold on, that's why. Okay. There you go.
Thank you,
Okay.
Your Honor.
You're welcome.
Right.
All right, let's go on the record in the matter of the state of Michigan versus Crystal Zamorsky, 251612, and the state of Michigan versus Crystal Zamorsky, 251614.
Good morning, Your Honor.
Okay, go ahead, counsel.
Do we have to do a reading first from the officer?
Oh, yeah, so I thought you were trying to put your appearance on the record. Okay, just good morning. All right, and so detective, your name for the record, please. Whoops, you're still muted.
Thank you, Your Honor.
Okay, very good, thank you. All right, your name for the record, please.
Detective Joseph Carwine, Police Department.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on November 15th, 2025, Officer Carpo was reported that she was dispatched to 1110 Sycamore Street regarding a larceny complaint. Officer Carpo reported that she arrived at the address and spoke with the victim, identified as a Dana Jakubiak. Officer Carpo reported that the victim stated that on 11/13, she noticed the gate located in the west side of her home to be unlocked and open, which was unusual. Officer Carpo reported that she checked her home security video and discovered that on 11/13, about 12:30 p.m., an unknown white female, later identified as the defendant, Crystal Zamorsky, is seen unlocking the gate and entering the yard and subsequently stealing items from a parked, unlocked travel trailer, which was located in the backyard. Officer Carpo reported that the victim showed her several home security videos where she observed and immediately identified the white female as the defendant from several prior police contacts. Officer Carpo reported the defendant is seen arriving at 1110 Sycamore with no shoes on and what appears to be a shorts or no pants. And a short time later is seen leaving via the same gate, wearing black boots and carrying a black bag, which was identified belonging to the victim. Officer Carpo reported she reviewed additional home video from the address, which showed the defendant running in front of the home, wearing the black boots and carrying the bag. Officer Carpo reported that the victim had checked the backyard and camper area and discovered items stolen from the camper and damage to the garage. And, the items stolen include a pair of black hunter boots, a Nintendo gaming console, Amazon Fire Stick, and this gate locking mechanism. Officer Carpo reported that she checked the defendant's status in Lean SOS and discovered that she had an outstanding warrant on the 27th District Court for a weapons offense. Officer Carpo and Kyle Cox arrived at the defendant's address located at 974 Eureka Road and made contact with her, where she was subsequently arrested on the local warrant and on the larceny. I spoke with the victim in the case the next day, and the reported items stolen appeared to be over $1,000, but less than less than 20,000. And the damaged property appears to be over 1,000 and less than $20,000. And Your Honor, may I note that the defendant is also a second offense notice, which indicates that on October 10th, 2019, she was convicted of a felonious assault in the Third Circuit Court in Wayne County.
All right, thank you. Upon examination of the complaining witness, I find the offense charge were committed and that there's probable cause to believe the defendant committed those offenses. Counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemp, appearing on behalf of my clients. Time to consent to the matter being heard via Zoom.
Thank you. Ms. Zamorsky, your name for the record, please.
Yeah, it's true.
Okay. And counsel, you're on the felony matter as well as on the assault and battery matter from November 13th. As to the arraignment on those matters, what are you requesting?
We waive formal reading. My client stands mute.
All right, the court will waive the formal reading. As to 251612, the court will enter plea of not guilty, schedule this matter for pretrial on November 25th. 1:45 p.m. And ma'am, you do have, as to the felony, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. In fact, you've had the opportunity to speak to an attorney today, correct?
Yes.
All right, the court's also signed the petition order for appointing an attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court's entering a plea of not guilty on your behalf on the felony matter, scheduling this matter for probable cause conference November 25th at 1:45. And as to bond counsel,
Your Honor, my client was gainfully employed. This arrest might jeopardize that. But that being said, she indicates she will come to any and all future court dates. She will comply with all provisions. I know financially she would have a difficult time coming up with a monetary amount, so we would ask consideration for any leniency this court could consider when determining an appropriate bond. Thank you, Your Honor.
okay, so ma'am, you're currently on probation, right? Out of the Third Circuit Court because you failed to complete probation. There's a warrant for your arrest. Is that the issue?
What is that? I'm not on probation at no Third Circuit Court.
No?
No, ma'am.
Are you on probation in this court?
No, I did drug testing for you and I passed every drug test that you asked me to do. And on my jail review, I talked to the probation lady. I was currently in the hospital and I emailed you guys the paperwork. I called and I didn't get no return phone call regarding that. And I still have the paperwork. If you need that, I can get that.
What's the, okay, hold on. Detective, what's the warrant that is pending for Ms. Zamorsky?
Your Honor, that is out of our 27th District Court. It looks like a weapons offense.
For jail review, and I was in hospital that day.
Okay, hold on, ma'am, hold on. Can you pull that one out, please? That must be the one from April.
It's dated, issued on the 21st of October of 2025, Your Honor, so.
Okay, do you have that file?
I didn't hear, I was walking over here. She's on jail review.
I know. Right, I need the file. Can we get the file since she's already in custody?
Okay, there's your note.
Does the offense date from April, Judge?
Yes.
Yeah, it's in yours. She fails up here for the jail review October 20th.
I talked to Natalie Shaw and I let her know that I was gonna be in the hospital.
No, ma'am, you emailed October 24th. And you didn't submit any paperwork. And as far as the email goes that you're addressing. And so then you were notified you needed to either post bond. And if you post the bond, we'd recall the warrant or you could walk in. You didn't do that.
I did email. I don't know if it didn't go through or not, but I guess I did do that.
You're not listening to what I said. You're not listening to what I said. Yes, you emailed October 23rd. And then I reviewed the email. You didn't attach any proof of being in the hospital. In fact, all you said on here was that you were sick. In fact, I'll read the email, ma'am. Yes, my name is Crystal Zamorsky. I had court the 20th. I have been very sick. I have told Marcy. She demanded the paperwork next day and told me, I don't know, or IDK, if you can reschedule my court date. I have to ask, she said, and that's wrong by law. You have to. I'm still very sick. And also some very, very serious things happened taking care of regarding my job with 2 or more employees that did identity fraud and had taken all my money. It's in the process of being handled. Also, the court needs to know my mother, Chris, calling police saying I hit her. That's a false report, but I had the police called that day to tell them everything going on. And I have got justice from not one officer. I'm tired of everyone lying and calling in on me with the most ridiculous things. Even I do biting, but sit at home until my mother kicked me out. Now I'm homeless. I want to know why I get cops coming to my house every single time. A person calls or makes a lie up any type of thing about me, period. They're at my door ready to put me in cough, period. Just like when I was arrested, my mom lied and said I hit her. That's the other sentence, period. I was sleeping when I was arrested, period. There's no proof, nothing, period. I don't understand how that's fair, period. I'm being harassed by a little by police and I want to have it stop, period. This is ridiculous and I'm tired of it. I'm to the point where I don't even want to be here anymore. I'm tired of everyone, family, the city accusing and treating me terrible. It's not fair. I want to have a call from the main person. I'm able, yell, speak to the judge personally. That'd be great. Can you guys please get a hold of me? Because last time I got there, nothing was ever mailed to me and no one ever returned my phone call, please and thank you, period. Have a good day. That is the email that you sent in October 23rd. The response to that, ma'am, was that you either needed to post a bond, and if you did post a bond, then we would recall the warrant, or you could walk in.
I apologize, I didn't get it. I
Ma'am,
didn't check my email.
stop. You sent an email, you should check your email. And you didn't do that. So don't try telling the court now that you were trying to come into court. So, because you just said that you were in the hospital. Didn't you say you were in the hospital? That's why you missed court?
Yes, I was.
Okay, not anywhere in this email does it say you're in the hospital. Your credibility is about nothing with this court, ma'am. Just see that right there. Okay. And so, counsel asked to bond.
Your Honor, just any leniency this court could consider. I believe that my client obviously realizes that there are consequences. She's not appearing in court. She's experiencing them. So we just ask for anything which would potentially allow her to get out of custody, or at least a 10% cash surety provision.
I do have a job that I'm supposed to be checking up on that, it's at a dental office. I can't check it then at home at my phone. You know, I lost a lot. My car got totaled September, a day before my birthday, and my whole bank account got frauded. I'm trying. It's just, I don't know, ma'am.
Ma'am, what I hear is a bunch of run-on sentences with a whole bunch of excuses that you think that are just coming into your head at the particular moment. That's what it sounds like to this court. You want to try to throw everything in to see if any of those excuses sticks. Where do you live, ma'am?
974 Eureka, Wyandotte.
Who lives there with you?
Just me and my mom.
Right. Well, your mom's the victim in the matter from just last week. So you won't be returning there, I can tell you that. So where else are you going to live then, ma'am?
I don't know.
What's that?
I don't know.
And who's the victim on the matter that you're currently on probation for?
What victim are you talking about, ma'am?
The assault case in Wyandotte.
I'm sorry,
I don't know.
the jail,
I don't
the
know
jail review. Let me clarify, the jail review.
What assault you're talking about?
For the jail review case.
What does that mean? It's not
The assault that I'm
assault.
talking about, ma'am, it shows on November 13th.
Yeah.
You have a charge of assault and battery.
How am I charged with assault and battery when I was never arrested for it? I wasn't even home.
Well, ma'am, let me just say this. The police report indicates they were dispatched to the home in regards to a domestic assault. You left the location prior to the officers getting there. And so then they issued you a citation, ma'am. Or I'm sorry, they did not issue a citation. A warrant was signed for that.
Against who? My mother who was stage 4 lung cancer, dying? Why would I hit my mother? And I was not even home. How is that even illegal? How is that legal? I wasn't even home and I got issued an assault charge because me and my mother got in a fight and I left because I didn't want to argue with
I
it.
wouldn't, don't talk about the specifics of the case, miss.
Where is it that you say that you're working? A dental office?
I have a dental office interview coming up this week, but I was working at Packray and I had two individuals bank fraud my account, and I followed up with Ecorse Police, and it's still going with that ongoing investigation. At Packray, I was working. They drained my whole bank account, my bank
Okay,
account.
so you don't have a job that you're working, you have an interview.
I was working last month, but I have an interview coming up this week. at a
With the dental
office.
office. Okay,
That's me.
okay. And so are you out on bond in any other jurisdiction?
No, ma'am.
Have you ever failed to appear in court for any reason?
No, ma'am.
Other than the jail review here?
No.
And,
I promise you, man, I'm trying to get my life together. Just I really, my family has been really.
I cannot understand what you're saying, ma'am.
Ma'am, I'm really trying to get my life together. My family and us been really under a lot since my dad committed suicide. I know what I've done. And I'm just asking if you're willing for me to get this opportunity to get this job and let me get my life back on track. I will not come to court.
Excuse me, who was the victim in the matter out of Livonia?
Livonia?
Yes, the stalking. Who was the victim in that matter?
That was my ex-girlfriend, and that wasn't even true.
Okay. Who was the victim? Who was the victim on the matter from Wyandotte that ended up being over at Third Circuit Court? Assault with a dangerous weapon you pled no contest to.
It was my brother. My brother lied against me in the police report. That's when my dad committed suicide.
And then who did the prior domestic violence you have, ma'am? Who's the victim in that matter? From 2018. Who was the victim that time? Was it your mom?
No.
Who was it?
I'm not sure. I don't even remember recalling that.
Okay, given all the pending, the matters on your criminal history, the assaultive nature of your criminal history, the assaultive nature of 251612, and the matters that are pending currently on the 2015, I'm sorry, the 251614 matter with Ms. Jakubiak, the court has some serious concerns. Detective, would you like to address bond?
Your Honor, I do have some concerns about the proximity of the defendant's address and where the incident happened, the victim's address. So I would recommend a GPS tether. And obviously no contact with any victims or potential victims or witnesses in that case, in the felony case today. And I would also recommend a $25,000 10% cash bond, Your Honor.
All right, the court's going to note on 251612 for the reasons this court stated on the record, as well as the concern this court has for Ms. Zamorsky appearing in court and for the safety of the community. The court's going to order a $10,000 10% bond on 251612. On 251614, the court's ordering a $50,000 10% bond with the following bond conditions. You're not to have any contact with Dana Jakubiak or Gloria Zamorsky. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to the premises at 974 Eureka nor 1110 Sycamore. You may return to Eureka, the Eureka Road address, one time accompanied by a police officer to pick up your personal belongings. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms or weapons. And you are not to be released without GPS tether through the Wayne County Jail. I'm sorry.
So what, my mom pressed charges on me? I can't even talk to my own mother?
Nope, sure cannot.
Thank you, Your Honor.
You cannot talk to your mom directly through a third party or otherwise. Not through writing, not through text message, nothing, no contact.
Your Honor.
Thank you, Judge.
Thank you. And just for the record, on the 25443, the court's recalling the warrant and will set this GO review also for November 25th.